Welcome to another episode of The Dissection. The question that a lot of people have been considering is the following. Should podcasts be regulated? Are podcasters broadcasters? What would the regulation of podcasts even look like? Is that type of regulation a violation of freedom of speech? Is it censorship? Are the political parties and the politicians who are calling for the regulation of podcasts afraid that they can no longer control the narrative and thus control the people? Critically, is the regulation of podcasts something that is necessary, and is it something that is in violation of the Constitution? Let's dissect this. Let's splice it. Let's decode it. Let's break it down in this episode of The Dissection. Well, if you haven't been following, it looks like ANC leaders and DA leaders have an appetite to control the podcast space in South Africa, a large appetite actually. They're using the comments that were made by MacG, Makaiva Mukove, on the Podcast and Chill episode as a justification and a pretext and as an example of why there needs to be regulation of the podcast space. But I feel like it's bigger than MacG. I don't think it's really about him or about that comment. Let's be honest about MacG. MacG occasionally crosses the line, especially in issues of identity, intimacy. He's crossed the line on issues of feminism, on issues which affect the LGBTIAQ plus community. He's crossed the line multiple times. The audience knows this. The public knows this. He's on a list somewhere. There are people who are always looking for MacG. And to be quite honest, when he does cross the line, he sometimes goes too far. So I'm not here to defend his comments, to justify his comments, or even to say that his comments were correct. That's not the intention of this podcast. The intention of this podcast is to look at that call of whether or not podcasts should be regulated, and whether or not that call is correct, right? So we've seen that when MacG crosses the line, when he goes across the line on feminism, when he goes across the line on the LGBTIAQ plus community, both of these communities have large and vocal advocacy groups on social media and on the ground. And whenever he does cross these communities, he frequently faces tough scrutiny on media platforms and national media platforms, social media platforms, and on the ground, right? Calls for cancellation come up. It's why he even wrote that book, Uncancelable, because he's been through this so many times that he feels that he cannot be cancelled. He is above cancelling. Whether or not that's true, time will tell. So after MacG crossed the line again, we saw new voices entering the chat. New voices different from the feminist community, different from the LGBTIAQ plus community. We saw now ministers, deputy ministers entering the conversation. We saw chairpersons of parliamentary committees entering the conversation, right? And particularly, the Minister of Communications was asked by DJ Fresh about this question. He weighed in, kind of sounding like he's in support for regulation of podcasts. This is what the Minister of Communications had to say. Listen.
Massive story this week has been the MacG Mini Dlamini story, where MacG sadly and unfortunately decided to body shame Mini in a way that I never thought I'd hear anything like this on any medium anywhere on the planet. And MacG is my boy. I love him to death, but I don't know that I can sit and say what he did should be allowed to it's not right.
Totally unacceptable.
But let's get into where I want to go, though.
Yeah.
You were tweeted by Kusela Diko.
Yeah.
And she says, "We will be called all manner of names when Parliament pushes for the regulation of podcasting, but the attack on Minnie Dlamini is simply not it. It's misogynistic, hurtful, and has no place in our society. What avenue for recourse does she and many other people who have suffered at the hands of these anything-goes platforms? At least licensed broadcasters have a responsibility to account to the Broadcasting Complaints Commission. Here on these platforms, nothing unless you have the financial muscle to litigate, which is a privilege not everyone enjoys. I hope this matter is in your very full in-tray, Minister Solly Malatsi." You saw the tweet, right?
Yeah, I saw the tweet.
Yeah.
Look, and let's start with addressing, the McG sentiments,
Yeah.
which in a country that has and continues to battle with gender-based violence, in a country that continues to battle with gender inequality, to have not only a podcaster, a prominent podcaster, perpetuating that vile attack on the dignity of women is totally unacceptable. The second point is that broadcasters have a responsibility to empower their audiences, right? To empower their audiences with information and the right way of doing things. A lot of entertainers discard their responsibility for that under the veil that, we are just there to entertain. That is nonsense. The third point I want to make is that traditional media has evolved, right? Has evolved to the extent that the structures that are there that look after ethical conduct and responsible broadcasting are not currently applicable in the podcasting space. That leaves a wide gap. It leaves a wide gap for this kind of unwarranted attacks on people and their dignity. And I think that it is the right thing, and we will be kicking off the process of looking how do we best ensure that we set up at least a structure that can give audiences the right to seek recourse when their dignity has been hurt by podcasters, and also when misinformation and fake news are spread to those platforms, because the Broadcasting Complaints Commission wouldn't be the right instrument in this instance. But my view is that we can't afford to continue with a space where there is no authoritative body that looks over responsible broadcasting of podcasting.
The minister wasn't the only person who was speaking about this. In fact, the conversation was actually initiated by the chairperson of Parliament's Committee on Communications, Kusela Diko, who weighed in as well. In fact, she was the first person I saw on social media doing interviews, having this discussion, making the call for the regulation of podcast. Kusela Diko is effectively making a call and a warning about a legal vacuum that allows potentially harmful content to spread unchecked. She argues that podcasts are growing at an exponential rate and that they fall outside traditional broadcasting laws and self-regulatory bodies, which raises concerns about hate speech, defamation, and personal harms without accessible remedies for the public. In response, what she's proposing is developing a regulatory framework. And she argues that you could have co-regulation or self-regulation to impose codes of conduct on podcasters and ensure that victims have recourse. She emphasizes that, or she argues rather, that freedom of expression is not absolute and must be balanced against dignity. She says your right to free speech does not supersede someone else's right to dignity. Surface level, that seems okay, but that's what this episode is about, looking into whether or not that's legitimate or whether they're going too far. There are some people who raised some comments about, well, Ms. Diko, you are not somebody who should be trying to occupy the moral high ground on various topics, because you yourself had to step down from a variety of things because of implications and allegations around, tenders and benefiting from tenders. So we're not going to talk about that, but you can go look up all of that if you're interested in seeing why they were making that particular call. For me, it was odd to see similar lines of arguments coming from the DA Minister of Communications, Solly Malatsi, as well as the ANC chairperson on the Committee on Communications. Why? Because they are always at odds, these people. Recently, Kusela Diko was accusing the Minister of Communications of abusing power and acting unconstitutionally. You may not have seen these statements, but on the 7th of April, 2025, Monday, the 7th of April, this is what was issued as a statement from the committee chairperson. Her statement started off as follows. The chairperson of the Portfolio Committee on Communications and Digital Technologies, Ms. Khusela Sangonitiko, expressed serious concern at what appeared to be attempts by Minister Solly Malatsi to erode state capacity and thwart South Africa's transformation laws. That was this year. Last year, on Sunday, the 10th of November, 2024, another statement. The chairperson of the Portfolio Committee on Communications and Digital Technologies, Ms. Khusela Sangonitiko, noted with grave concern the decision of the Minister of Communication and Digital Technology, Mr. Solly Malatsi, to withdraw the South African Broadcasting Bill from Parliament as reported in the Sunday Times. The Portfolio Committee has not yet been formally notified of the withdrawal of the proposed legislation in line with the rules of the National Assembly. Right now, the ANC and the DA are in court over the VACT Act, over the Employment Equity Act, and they are going to court at some point over the Expropriation Act. If you think about this, the DA, ANC are not seeing eye to eye on VAT, they're not seeing eye to eye on the budget, they're not seeing eye to eye on BELA, NHI, Expropriation Act, Employment Equity Act, but they're seeing eye to eye on the regulation of podcasts. Make it make sense. Make it make sense. That's why we're here. That's why we're having this episode of The Dissection. The question that then arises is, what do the ANC and the DA have in common to the point that they can agree on this issue of the regulation of podcasts? Both parties rely heavily, as things stand in status quo, on mainstream media for support. Both parties rely heavily on donors to reach the public through posters, t-shirts, etc., radio adverts, SMSs. All of that stuff requires lots of money from donors. Both parties want to remain in the number 1 and number 2 positions so that they can continue to play the dance called GNU. And they are aware that podcasts are disruptive, and they are likely aware of the impact. In fact, they are aware of the impact that podcasts had in the 2024 US elections. In the 2024 US elections, podcasts played a prominent role. It was called the podcast election. Both candidates had to go on various shows to try and reach younger audiences and audiences who had tuned out of mainstream news. Let's be very clear. Millennials and Gen Z or Ama 2000s, they don't consume media in the same way that the older generations used to. If you think about statistically in South Africa, the median age is 28. And if you think about how the average 28-year-old consumes content, they're not watching programmed news at 7 p.m., etc., etc. No. If you think about how they're living and how their lives are busy, they're consuming content on the go. They're consuming content on demand. They're using social media apps like TikTok, Instagram, and Twitter to get news update and to stay informed. Then they watch their shows on demand on Netflix, Disney+, Showmax. They watch their news on other platforms like YouTube from voices that they know and trust. They're not just going to go and take the word of SABC as being sacrosanct or as being the word which was given to Moses on the mountain along with 10 rules on 2 tablets. No, that's not how people consume content. And they're justified in doing so, right? It's important. It's important to touch on that issue of why people have also tuned out of mainstream news. For a long period of time, the news was a trusted source of information, a trusted source of opinion. But at some point, the media lost the script and started playing the game of politics, descended into the arena, and started acting in weird ways. And everyday people have noticed how the mainstream media ignores certain issues and how they give certain people a pass. Let's look at some South African examples. In South Africa, there was a lot of news coverage on the EFF involvement in VBS Bank. EFF was alleged to have obtained 16 million rands from VBS Bank. 2 billion was looted. 2 billion. From VBS. 16 million rands found its ways, according to the reporting, to EFF. There was so much media coverage on that. That was the scandal that Daily Maverick, all of these other platforms chose to focus on, right? Trying to figure out, where did Julius Malema shop? What happened when they went to Durban July? What happened when they went to Sandton Mall? What happened? What happened? They were focused on the EFF. My whole question the whole time was, but the EFF is not governing Limpopo. Which municipalities actually deposited money? Which people were involved in those deposits? Who was responsible for that? Later, much later, we started hearing about Thembi Simelane, mayor of Polokwane, and how she had deposited money into VBS on behalf of the municipality, how she had allegedly received loans from a VBS middleman after the deposit was put in. And we only started hearing the story when Thembisi Melane was refusing to allow Advocate Pretorius and other people to access information that was in the Department of Justice that they wanted to use in prosecution, because that information was not supposed to be necessarily just given to them for those particular purposes. All of a sudden, we started hearing these reports. By the way, she was removed from that position and then she moved to a different ministry. As soon as she stopped being Minister of Justice, the number of news articles dropped. People would have been aware of that. Well, if you care about grandmothers and grandfathers in the way that you said you care about grandmothers and grandfathers, firstly, why didn't you tell me about Thembisi Melane earlier? Secondly, why did you focus on the EFF? Thirdly, why have you lost appetite and interest? Same applies to Khumbudzo Ntshavheni. She's accused when she was municipal manager of approving a tender which had not even been to a particular company, which didn't even bid. They were supposed to put tenders in envelopes inside one particular box. The box is opened at 10 a.m. They go in, they adjudicate the tenders. That company didn't even put in their envelope in that particular box. The judge in the case referred the matter and her conduct as municipal manager to the NPA for prosecution. We heard some reporting about that, but as soon as things seemed to have simmered down, the reporting went away. The public can see when the media is playing games with them. The public can see when the media is taking advantage of their trust and when they are trying to manipulate them. Clearly, there are some things that Floyd Shivambu and others have to explain when it comes to VBS Bank. They do have to explain. The Matodzi affidavit named Floyd Shivambu, named Julius Malema. They have to explain. However, the focus on Julius Malema was disproportionate to the focus on Thembisi Melane and the other people who are criminally accused and going through a trial now, although that trial is taking a long time. It was disproportionate. Think about this. The energy for the Gupta leaks. Amabungane actually leaked a lot of information that they were not supposed to leak. Daily Maverick covered it and they said, we have to do this in the interest of the whistleblower. We're going to let you know in the interest of the public knowing. When it came to who contributed to the CR17 campaign, the information leaked and the media houses were like, no, we have to wait for the courts to determine what's right, what's wrong. We're not going to tell you who donated to President Ramaphosa. We're not going to let you know that information. All of a sudden, Amabungane didn't care about leaking or didn't have that same principle of leak information in the public interest, protect and celebrate whistleblowers. Even when you think about the energy for Gupta leaks, was it comparable? Was the coverage commensurate to the coverage that was given to Phalaphala Farmgate scandal, where foreign currency is alleged to have been hidden in the sofas, foreign currency that Hazim Mustafa brought into South Africa, which was not declared to SARS in violation of multiple laws? The coverage, no leaks. It's just light touch. They did cover it because they had to cover it. At some point, it's out there. You have to give some coverage. But the coverage has always been light touch. Light touch. Light touch. When it's Zuma, it's hard touch. When it's Zuma. When it's Malema. We can see that. It's evident. This is why people started moving away. Even if you think about the Hunter Biden laptop story, at some point, Facebook was blocking people's accounts for talking about the Hunter Biden laptop story, reporting which was justified long term. It was justified. It was very clear that there was a story there. But at some point, the social media platforms were behaving in a way which was uncouth. So people have come to realize that mainstream media is not necessarily a trustworthy entity. And that's why they've moved away from mainstream media. Aside from the fact that people consume news in different ways now, there's also the thing that they can see when they're being manipulated. And oftentimes, there aren't real deep dives done by social media into issues that the public is concerned about and really wants more information about. Think about 2024 and why it was different for the American election. Donald Trump went to various podcasts because he knew that the media was not going to give him any good coverage, any good airtime. Trump appeared on 14 major podcasts or streams during the campaign. This included the Joe Rogan Experience, Logan Paul's Impulsive, Theo Vaughn's This Past Weekend, all shows with predominantly male audiences. Combined, those appearances accumulated over 70 million YouTube views. and many more on social media platforms. Kamala Harris, when she saw that this thing was working, employed a similar strategy. She appeared on podcasts such as Call Her Daddy with Alex Cooper, which is the second biggest podcast on Spotify after Rogan. She appeared on Club Shay Shay with Uncle Shannon, the football legend who is now going through his own issues because of his tendencies. Anyway, she also appeared on All the Smoke with Matt Barnes and Stephen Jackson. All of these shows were popular with her two main target demographic audiences, young women and black men. She played the podcast game too. It was a podcast election. Controversially, Kamala Harris did not appear on the Joe Rogan podcast, and there were people who thought that she should have appeared because it contributed to her losing the election. I'm one of those people, to be quite honest with you. I think that Kamala should have played the podcast game more and earlier. I think she was relying on mainstream media too much to win the election, and also on the idea of Hollywood celebrity endorsements, the Beyonce and the Cardi B thing. The stimulus package didn't work. The Taylor Swift, Beyonce, Cardi B stimulus package didn't work this time around. People are tired of celebrities as well. Many Democratic voters stayed at home in the last election because they were not inspired by Kamala. Maybe if she had gone to those podcasts, maybe if she had gone to Joe Rogan, it would have helped her to get her voter turnout from the people who already support the Democratic Party but are concerned about you to show up. I think that was part of it. So podcasters have disrupted how information is spread. They've broken through the media manipulation of society. And that's why people are going to podcasters. That's why they're going to comedians. That's why they're going to those spaces, right? People are going there because they're tired of manufactured consent. They're tired. Now, to understand the way power is maintained by the elites, you need to understand the manufacturing of consent. And in fact, it's my opinion that the reason why there is this concern about podcasts is because there's a concern now that the media will no longer be capable of manufacturing consent for the benefit of those in power and the elites, because the civilians, the people, can go somewhere else. They have options now. There is a book, a 1988 book by the late Noam Chomsky and Edward S. Herman called Manufacturing Consent. Guess what? You can't find this book at Exclusive Books. You can't find this book in many South African bookstores. I don't think that's by accident. I don't think they want the public to know how consent is manufactured so they can continue manufacturing the consent. If you're tricking the people, if you're tricking the public, it's not in your interest as the trickster to let the public know how you're conducting those tricks. Let me tell you now, get this book if you can. Manufacturing Consent by Edward Herman and Noam Chomsky. You will get an idea. This book explains how the media limits and curates the democratic process and public opinion. For a full dissection on the book, join our book club. This is going to be on the book lab. The book lab is the members only book club where we do book dissections, book dives. We do synoptic and analytical reading of text to make sure that we can elucidate the situations that we're going through, elevate our information base, and make sure that they're not going to be able to do what Bob Marley said. Don't let them fool you. Don't let them school you. You got a mind of your own. That's what Bob Marley said. Powerful words from the man. So let me just discuss a small part of the book and explore and explain what that book is talking about. Because this book talks about, in chapter 1, the concept of the propaganda model of mass media. The book says that mass media serves as a system for communicating messages and symbols to the general populace. It is their function to amuse, entertain, and inform, and to inculcate, which is to put values in you, values, beliefs. Inculcate means to place in you, right? Put the values, beliefs, and codes of behavior that will ingrate them into the institutional structures of the larger society. The book explains how the mainstream media space is consolidated into oligopoly, limiting the options that people have with very few players. The book explains that as an ordinary viewer, you are not actually the customer, or not always the customer. You are very often the product. You are the thing that they are playing with. The mainstream media is not actually interested in every viewer, and the book explains this. It is particular stakeholders that it prioritizes and particular viewers that it panders to. The mass media then has 5 filters in the propaganda model which influence what they show to you. The dominant mass media, number 1, you have to know, this is the first filter, is that they are large profit-based operations, and therefore they must cater to the financial interests of owners such as corporations and controlling investors. In South Africa, the big business owners are people like Johan Rupert of Remgro, Koos Bekker of Naspers, right? These two men are not only business leaders of large corporations, groups of companies with multiple interests in multiple industries. They actually own two media houses. Remgro owns ENCA. Naspers owns News 24. So can you see already the consent that is being manufactured there is at a hectic level there. Manufacturing this umqondo, how we think, how we observe, because they set the agenda, not necessarily in your and I's interests, but in the interest of the stakeholders, right, and the owners. So that's the first thing. Number two, the second filter, the news media caters to the political prejudices and economic desires of their advertisers and their customers. Their preferences and fears of the preferences and fears of those stakeholders are prioritized, right? Not necessarily yours. It's the advertisers and the people who buy what the advertisers are advertising. That's what the media is focused on. That's what they spend a lot of their time on. So the news that we watch is not neutral. It's for advertisers and their customers. The agenda that is set by the news is for middle-class homes, for professionals, and for those who own companies and work at those companies. They are the ones who are being sold the car insurance that you always see being advertised. Buy this insurance from this company at this amount. And it's always 2019 such and such with so many miles. Do you know how many people are driving a 2021 car right now? Very few. Always look at those car commercials, right? The car insurance one. It's always some car that is 2021. So-and-so is a doctor, where, and they are buying this car, and this is how much they are paying for insurance. You can get the same insurance. People are not driving those kind of brand new. People are in the second-hand market heavy. So they're not even... If you look at those car insurance adverts, you'll see who the target market is, right? For a lot of the mainstream media advertisers and who they are really trying to get to. So they focus on keeping those people watching and to encourage those people to buy the products that the advertisers are selling. So in order to do so, the media has to provide them with entertainment that suits their interests, their politics, and that agrees with their worldview. That's how the media operates. That's how Now, I want you to consider this data right here. If you consider this data from Stats SA and then consider who a company like DSTV is considering as its priority for agenda setting, you'll see how the second filter works. In January of 2025, Statistics South Africa released the 2022-2023 Income and Expenditure Survey. The data indicated large patterns of income inequality in South Africa. White-headed households had significantly higher income and consumption expenditure versus other population groups. White-headed households had significant higher median income and consumption than other population groups. On average, white households earned the highest income of $676,375 per annum, followed by Indian and Asian-headed households at $417,431 per annum. Colored-headed households were at $260,816, and Black African-headed households were at $143,632. You can see the discrepancy there. The average household income of white-headed households was almost 5 times higher than that of Black African-headed households and almost 3 times higher than the average household income of colored-headed households. So if you think about that, you begin to see who they're advertising to, right? Sometimes you're watching, but you're not the viewer that they're watching for. You're not the customer, you're the product, right? So think about this. So the third filter is pre-packaging. Media gets a lot of pre-packaged information from government and political party sources. The large bureaucracies of the powerful subsidize the mass media and gain special access to the news by their contribution to reducing the media costs of acquiring and producing news. So ministers, departments will give the media reports, etc., because journalists are overwhelmed, because those news houses are not being adequately staffed. They don't do independent research. They rely on what they've been given by the statements, the ministers, the politicians, the court papers, etc., and then they report on that. That is the pre-packaging that creates a filter. The large entities that provide this subsidy become routine news sources and have privileged access to the gates. Non-routine sources must struggle for access and may be ignored by the arbitrary decision of the gatekeepers. So if you're not one of the people who's always speaking to the media, if you're not on the WhatsApp groups for the different departments, you're not necessarily going to be considered as a source, even if you have a legitimate thing. Editorial distortion is aggravated by the news media's dependence on private and governmental news sources. If a given newspaper, television station, magazine incurs disfavor from these sources, it is subtly excluded from access to information. That's why sometimes you don't see certain analysts on TV anymore. You don't see certain voices on TV anymore. It's because if they are deemed to be on the wrong side, offside, even if it's in the interest of the people, they may be withdrawn because there's a lot of gatekeeping, pre-packaging. The investigative reports released by investigative journalists are given to them by political insiders who are seeking to score points against their rivals and protect their principles. That's why you'll see some investigative reports and you won't see others. By the way, these investigative reporting agencies, many of them are funded by Michel Leroux of Capitec through his entity called Millennium Trust. So he's funding through Millennium Trust, Amapungane. He's funding Freedom Under Law. He's funding Corruption Watch. So even if they're looking at legitimate things, they may not be showing you all of the legitimate things that you need to see. You see? And that's where the rubber hits the road. Manufacturing consent. They are cooking us. They are manufacturing what we think. And we need to be aware. We need to break those chains of media manipulation through knowledge. So there's a filter of drops of dissent to manage audience flack. Due to the valued audience and valued stakeholder status, the mainstream media has to manage pushback. The book says the prospect of eliciting flack can be a deterrent to the reporting of certain kinds of facts or opinions. So when it's talking about flack, it's referring to negative responses to media sentiments or media programs. These negative sentiments are letters, complaints, lawsuits, legislative actions. So flack can actually be quite expensive to the media, either due to loss of advertising revenue or due to the cost of legal defense or defense of the media outlet's public image. So flack can be managed and flack can be curated. So flack can be organized by powerful private influence groups, the think tanks, the NGOs. Mainstream media then gives flack platform to some of those entities, but not to other entities. And those who get are not given too much platform. Flack in and of itself is also produced by government officials when they attack the media for its coverage. And when they do this, when they attack the media for its coverage, it's all part of actually building credibility of the institutions to create perceptions of balance while managing what the audience looks like. So if one minister is like, no, ENCA, and then ENCA puts that on their own platform, now it's like, yeah, no, ENCA doesn't necessarily get along with these guys, when you need to be aware that they are managing the flack. The flack is not necessarily flacky. Keep that in mind. The fifth one is managing dissent through villainization. This filter concerns the specter of a common enemy, which can be used to marginalize dissent, right? The ideology that is given to the media helps mobilize the populace against an enemy. And because the concept is fuzzy, it can be used against anybody advocating policies that threaten dominant interests. So in the 1980s in America, it was anti-communism. Even if you listen, I was listening to John Voster doing an interview with somebody recently, and he kept talking about communism and socialism and communism. This one is a communist. And the guy asked him, he said, but some of these people you're calling communists, you don't have any evidence. He was like, well, you need to trust us, etc., etc. So that is part of manufacturing consent. In the 2000s, it was the war on terror, right? In South African elections, it was Doomsday Coalition. Doomsday. And at some point it was radical left. And then at some point it was radical economic transformation. That is the enemy. All of those things are part of manufacturing consent. The enemy is frequently in the circles of the EFF and MK, and these ones are the doomsday ones. The other ones are not doomsday. They're not doomsday. This is done to push the middle class and the wealthy South African audiences and anyone else who's really watching away from those political options and to cultivate fear of these political options in order to manufacture consent. Do you see why the book matters? You may not agree with everything the book says, but the book is clearly important because the book, they want to regulate podcasts so you don't hear this, man. I'm just saying. So when I heard this thing about regulation of podcasts and how they are talking about this almost on the same page, I knew that no. Something is not right there. It seems to me that they're intimidated by the podcast space. Channels, particularly channels, big channels on YouTube, such as SMWX, have interviewed ministers, mayors, prominent voices, former presidents. Floyd Shivambu actually went on SMWX first to announce his joining of the MK party. So many politicians have gone to Podcast and Chill to access that male-dominant audience, that large, over 2 million subscribers, chillers. So many, millions. What they've built there is phenomenal. I don't agree with everything that MacG says. And sometimes MacG just wants to ask everybody, but did you smash? Did you smash? Someone will be talking about, yeah, so if you look at the economic graph and if you look at the GDP numbers have been on 1% over the last decade, and unemployment right now, youth unemployment is sitting at 60%. MacG will be like, yeah, but did you smash? Smash or nah? Smash or nah? So, look, I understand it's that kind of a podcast. I watch the podcast, but sometimes MacG will just go on a tangent. He'll just, it is what it is. That's what he does, right? And don't take that as a justification for anything offensive that he said. I definitely don't agree with a lot of what MacG has said. So when I heard this, I knew that no, man, it's not just about MacG. I've been looking at SMWX and I was like, when are they going to come for this guy? You know, you look at other guys, you know, King David, you look at this, you're like, when are they going to come for these people? You know, there's so many. DJ Smooth's got that Hustler's Corner. Some of the guests there, you're like, I don't think they like this. I don't like this. I don't think they like this mix. These combos they don't want these combos out here. Free combos of this nature. Someone can just go to SMWX and go viral. They didn't go to SABC, they didn't go to ENCA, they didn't go to News 24. In fact, those platforms, some of them are struggling. News 24 is struggling in the podcast game. I don't want to lie. They're struggling right now. So when I thought about this, I was like, But what I want to do in this part of the video, I really want to look at this legal side of the issue. Is there a legitimate case on the grounds of legitimate limitation of rights? What does the law say? What do the courts say? You know, let's look at that, because what Kusela Diko was arguing at the beginning is that no, you have, you know, free speech, but free speech is not absolute. So let's talk about that. Let's look at that. And I want to give you what the law says. You can go check this for yourself as well. So one thing you need to know is that freedom of expression is a foundational right in South Africa's constitutional democracy. It's an important right. Section 16.1 of the Constitution guarantees the right to freedom of expression to everyone, including freedom of the press and other media, and the freedom to receive or impart information or ideas. This protection extends to all forms of expression, whether via newspapers, broadcasts, or internet platforms like podcasts, and to both popular and unpopular speech. The Constitutional Court has repeatedly affirmed that this freedom is fundamental to our democratic society. Notably, Section 16.2 of the Constitution carves out narrow exceptions, right? Narrow exceptions. So these are the exceptions. Expression that amounts to propaganda for war, incitement of imminent violence, or advocacy for hatred. And it gives a list of grounds for advocacy of hatred that constitutes incitement to harm. That is not protected. Aside from these categories, all other speech is protected, although it may be subjected to limitation under Section 36, the General Limitations Clause, if a law meets strict requirement of limitation of under the provisions of Section 36, which we'll talk about a little bit later. Okay? So the constitutional design reflects a conscious decision to favor free expression and tolerate a wide range of ideas, even those that shock or offend. As the Constitutional Court observed, ordinarily, all categories of expression, save those excluded by the Constitution itself, enjoy a constitutional shield and may be restricted only in a constitutionally compliant manner. There is no category of unprotected speech called offensive or indecent speech beyond the Section 16.2 carve-out. Speech does not lose protection, however, merely because it's hurtful or vulgar. Importantly, the right to freedom of expression protects both the speaker and the audience. In the case of Case and Another versus Minister of Safety and Security 1996, one of the first landmark free expression cases, the Constitutional Court struck down an apartheid-era censorship law that had criminalized the possession of indecent photographic material. Right? In doing so, Mokgoro emphasized that the Constitutional Court protects not just the right to speak, but also the right of listeners to receive information and ideas. She wrote, "My freedom of expression is impoverished indeed if it does not embrace also my right to receive, hold, and consume expressions transmitted by others. A law which deprives willing persons of the right to be exposed to the expression of others gravely offends constitutionally protected freedoms both of the speaker and would-be recipients." The judgment further recognized that free speech, free expression is instrumental to truth-telling and the people's right to know in a democracy. Even material deemed pornographic or offensive to some was held to implicate constitutional freedom, especially when consumed privately by consenting adults. So this case underscores a critical point. The Constitution does not allow the state to act as a paternalistic censor for adults. Expression cannot be curtailed simply because it is distasteful or could be harmful to morals. There must be a truly compelling reason. The Constitutional Court has on numerous occasions protected offensive or critical speech to uphold this principle. For example, in Laugh It Off Promotions versus South African Breweries, SAB, in 2005, the court sided with the small grassroots publisher who parodied South African breweries' trademarks on shirts to deliver a social critique. SAB had actually sought to ban the t-shirts under trademark law, and they were calling the parody unfair and an unjustified racial slur on its brand. The courts, right, there were two judges who wrote concurring judgments, Moseneke J and Sachs J. They concurred and they actually overturned the ban, stressing that trivial economic harm or offense to powerful corporations' reputation could not outweigh free expression. Crucially, Sachs J warned against the chilling effect that using heavy-handed legal mechanisms could have on free speech. Even the threat of litigation can stifle legitimate debate. Large businesses have substantial influence, making them ripe targets for parody and criticism. Yet, using legal action could serve as an over-deterrent. It could chill public discourse because the law could be used to encourage prospective speakers to engage in undue self-censorship to avoid a ruinous lawsuit. This vivid observation applies beyond trademark law. It captures the general concern that onerous regulations or legal threats are actually used and can be used to cause speakers to self-censor, which impoverishes public debate. Laugh It Off, because no likelihood of substantial economic harm was proven, the court refused to silence the parodic expression. The outcome affirmed that all expression, including commercial, satirical, or irreverent speech, is prima facie protected, and any restriction demands strong justification. Now think about what the portfolio chairperson on the Committee of Communications, Parliament Portfolio Committee chairperson, saying, we must regulate podcasts. Then you have the Minister of Communications coming to say, we must regulate podcasts. What is that going to do? Or what is it supposed to do? Does that not have the same chilling effect that was discussed in the Laugh It Off Promotions case versus SAB? Is this not what Sachs J was warning against? Another instructive precedent is Democratic Alliance versus African National Congress 2015 case, which dealt with an SMS which was sent during an election campaign. The opposition party, the Democratic Alliance, which Solimalati is from, had sent voters a message accusing the president of which was Jacob Zuma at the time, of having stolen public money based on the findings in the Public Protector's report on Nkandla. The ANC sued under the Electoral Act's prohibition on publishing false statements to influence an election, arguing that the SMS was false. But the Constitutional Court held that the SMS was political expression and opinion and not a factual assertion, and thus not caught by the statute. In passing the law, analyzing, that's what the word means. In passing the law, the court stressed that the penal provisions restricting speech must be interpreted narrowly lest they undermine the vital discourse of an election. It recognized that robust political debate may include vehement, caustic, and controversial criticism, which is essential to free and fair elections. Even though the court acknowledged that freedom of expression is not absolute and must be balanced with the right to fair elections, it ultimately favored an interpretation that avoided censoring an expression of opinion on a matter of public interest. That DA and ANC 2015 case reaffirms that, especially in the realm of political speech, the default position is to allow more speech, more kuluma, not less bua, not less kuluma, and to rely on counter speech or political accountability rather than legal gagging, except in clear cases of unlawful falsehood or incitement. From these constitutional principles and cases, we therefore derive several key points relevant to the podcast regulation debate. Number one, offensive speech is protected. The fact that podcast content may be in poor taste, did you smash? Did so-and-so smash? Smash. All of those smash beggars that we don't want to necessarily hear does not remove it from constitutional protection. As the famous dictum from the Handyside versus UK case, which is a European Court of Human Rights case, states, freedom of expression applies not only to inoffensive ideas, but also to those that offend, shock, or disturb any sector of the population. South Africa's jurisprudence is in accord. The Constitution tolerates a high degree of offensive or unpopular speech as the price of liberty. Regulation cannot merely be justified because the speech is disparaging or impolite. More substantial harm is required. So that's the first thing that we've established. Number two, no prior restraint or licensing of free speech is sanctioned. The Constitution's structure and court decisions exhibit a strong aversion to prior restraint and censorship. In Print Media South Africa versus Minister of Home Affairs 2012, which is an example, the court struck down provisions that required publications to submit certain content for classification before publishing, citing the chilling effect on speech and the availability of less intrusive post-publication remedy. By analogy, forcing podcasters to pre-clear their content or to obtain licenses, even indirectly via platform gatekeeping, would face serious constitutional hurdles. Section 16 demands that any limitation be narrowly tailored. A blunt regulatory scheme casting a wide net is presumptively suspect. It's suspect. Third thing is that we have to establish that when you are balancing dignity and other rights, you have to be quite cognizant of whether there are other remedies and whether or not the balance is not necessarily going to go in free speech favor. It's true that the right to freedom of expression must be balanced with the right to dignity, right? And other rights. The Constitution values human dignity highly and does not make free speech an absolute trump card. Indeed, one of the cases in Khumalo versus Holomisa, the court recognized the harm of defamation and adjusted the common law to better balance media freedom with individuals' reputational rights. However, the method of balancing matters. Hey, that method matters. South African law prefers After the fact remedies like damages for defamation, apologies over prior restraint or broad censorship. The idea is that false or harmful speech can be addressed once it occurs rather than empowering a regulator to preemptively control speech. The proposed podcast regulation, by creating codes, oversight bodies, risks presumptive constraints or punishment that exceed what is necessary to vindicate dignity. Crucially, existing defamation and hate speech laws already provide remedies, which I'll discuss a little bit later. Thus, the incremental benefit of a new regulation must really be weighed against the significant harm and the chilling effect it would impose on lawful expression. Let's now talk about Section 36, which is the limitation clause. Section 36 of the Constitution deals with the limitation of rights. It states the following: the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including the following. 1. The nature of the right. 2. The importance and purpose of the limitation. 3. The nature and extent of the limitation. 4. The relationship between the limitation and its purpose. And 5. Whether they are less restrictive means to achieve the purpose. That last one, whether they are less restrictive means to achieve the purpose, is big in jurisprudence. It's big in case law. And in this case, they are less restrictive and effective means to achieve the purpose of protecting people who may be victims of onerous free speech. Right? They are. Defamation law. South African defamation law provides a robust remedy for individuals whose reputation and dignity are harmed by false statements. If a podcaster falsely accuses someone of misconduct or seriously insults their reputation, the injured party can sue for defamation in civil court. Bonang sued someone for 500,000. Right? Former Miss South Africa sued someone as well for naming them in a book. What is that book called? Bear. Basitsana Kumalo, right? She sued somebody and won. She was successful. We already have case studies to prove that those things exist. The Human Rights Commission exists. Some podcasters have been taken to the Human Rights Commission for problematic statements that they've made. They've gone there to the and they will start going on Twitter apologizing. I would like to hereby apologize and retracting. That's already been done. Crimen injuria and harassment. South African law recognizes crimen injuria. How do you pronounce that? It's crimen injuria, right? So crimen injuria is something that is recognized, the unlawful and intentional impairment of another person's dignity. This has been used in cases of extreme verbal abuse, for instance, if you're talking about racial slurs which are directed directly at somebody. If a podcast host directed, sustained, personally targeted obscene insults at a private individual, it is conceivable that that could amount to crimen injuria, which is a criminal offense. You go to the police station, you open your case. That's available. There are less restrictive means available in status quo. Available right now. It should be clear, therefore, that the regulation of podcasts is not necessary, nor is it legitimate. This is because the platforms have rules of conduct themselves, because people have multiple avenues of recourse, and because those avenues of recourse are less restrictive than regulation and censorship. It seems that the political parties and the leaders of those political parties want more control of the discourse, but this is not really healthy. And this is potentially being done to intimidate podcasters and to keep them away from speaking on certain topics and from saying things which are positive about other parties and giving platform to other parties and other ideas. People are afraid of the Joe Rogan effect in South Africa, the SMWX MacG effect. They're afraid of that. It's amusing to me because gambling companies are advertising without much limitation on TV. And they're advertising in unethical ways on social media platforms. Some of these gambling companies have even told the advertising regulator that we're not under you. You can't do anything to us. We don't want. We're going to keep on advertising the way we want. There have been cases that have been taken to the advertising authority. I'll do an episode on them one of the days because they've been quite interesting to read. I was researching them for the Betway episode that is currently out on the Book Lab, which is the members only side of the channel. So they're not talking about how to regulate, the gambling companies, the Betways, all of these companies, Sporting Bet, etc., etc. There's a real harm from what these companies are doing. Poor people are losing their homes. People are committing suicide. These companies are acting in very, very funny ways. There's no discussion about regulating how they advertise on mainstream, how they advertise online by the Department of Communications. But there's discussion about podcasters. How is this on the agenda even? How can the committee chairperson say this is one of the things that needs to be put in the basket as a priority? It's also amusing because there's been no support for content creators from the state in a real way. No funds have been set up that people can apply to, people in townships, people in rural areas, to get camera equipment, to get microphones. People are saving up and building the ecosystem themselves. People are building this from the ground up, from the mud. So now that there's some structure, there's some ecosystem, there's some network, now all of a sudden the politicians are coming around saying, Lentole, is it regulated? Lentole, why not nikhuluma too freely, lana? That's sounding like bullying, man. It's sounding like bullying. For the government to come in now when there are millions of listeners and influence with which some of these podcasters have with the threat of regulation is hypocritical. You didn't build it. Why are you trying to get in? What's next? The regulation of Amapiano because there's a minister who didn't like the song Abantwana Ngama Uba. Justifiably, you can start saying that. But like, no, we don't like Hosh Karimaima, the song. So now we must regulate hip-hop, dog. Hi, guys. What are we doing here? What are we doing? Guys, I'm done. I want to hear what you think about this topic. Let's have a conversation in the comment section. Do you think podcasts have gone too far? Or do you think the politicians are up to something? Let's have a conversation. I hope I've broken it down to its barest bones. I hope that the lab has delivered lab results that you're satisfied with. Let's have a conversation in the comments.